Retroactive child support for now adult children. Supreme Court of Canada clarifies the rules. When a recipient parent applies to vary child support retroactively, must the beneficiary child still be a child of the marriage at the time of the parent's application? Or can the parent apply even though the so-called child has now reached the age of majority? In a decision that has important ramifications for pairs and parents who have historically neglected their child support obligations, the Supreme Court of Canada has clarified the principles around when an application to retroactively vary child support can be made. The ruling builds on the court's prior conclusions on eligibility to bring an original application for retroactive support. In Michael v. Gryden, the parents had been in a common law relationship and had one child together. When they split up, they reached an agreement on child support that was formalized by the court in 2001. However, the father underreported his income at that time and continued to do so for the next decade, essentially shortchanging the mother on child support while the order ran its course. His support obligations were officially terminated by the court in 2012. Having learned of the father's income-related misrepresentations after the fact, the mother applied in 2015 to retroactively vary child support for the years spanning 2001 and 2012 to bring it in line with the true income figures. The wrinkle was that at the time of her application, the child had already reached adulthood. The British Columbia lower court judge issued a ruling in the mother's favor, but the BC Court of Appeal overturned it. On subsequent hearing before the Supreme Court of Canada, the lower court judge's original findings and conclusions were restored. The Supreme Court of Canada examined its own prior landmark decision called DVS, where it ruled that an original application for retroactive child support under the Divorce Act must be made while the child in question is still a child of the marriage. However, the rule was different for variation applications under provincial legislation. In this case, the Family Law Act in British Columbia. Under that statute, there is no requirement that the child must be still a child of the marriage at the time of the application for retroactive support. The court noted that the British Columbia's Family Law Act confirms the general philosophy that the child support is the right of the child. It also clearly imbues the court with the authority to change, suspend, or terminate child support orders, and to do either prospectively or retroactively as it sees fit. The court's review powers are not tied to the dependency status of the beneficiary child. Although this is admittedly different from the regime under the Federal Divorce Act, the two levels of government are always free to make different policy choices, as they had done so on this issue. And it was the distinction that all courts were required to respect and uphold. Turning to the specific facts of the Michael and Gryden case, the Supreme Court confirmed the lower court's conclusion that he had the authority to review the prior support order. The judge was also justified in finding that the father, one, had underreported his income for almost 11 years, and two, had neglected his child support obligations in the past, and three, would not experience hardship if a retroactive award was made at this point. The mother's delay in seeking retroactive child support was also reasonable. In the end, the Supreme Court of Canada overruled the British Columbia Court of Appeal and confirmed the lower court's judge's order awarding mother $23,000 for unpaid support dating back to 2001. So what do you think? Did the court make the right decision in adjusting child support retroactively in this case? You can like and share this video. You can subscribe by clicking the bell at the bottom. You can leave your comments in terms of whether you think the court got this decision right in the comment box below. I want to thank you for watching our video today. I'm Russell Alexander.